Welcome everybody to the third and final podcast in our podcast series on the ICC Arbitration Rules 2026. I'm Jack Hobbs. I'm an associate in the dispute resolution team at Clarkslegal, and I'm joined again by Christopher Howitt from Three Stone. Chris, good afternoon.
Good afternoon, Joe.
So, in our first two podcasts in this series, we discussed the high-level key changes in the latest version of the rules, and then the expedited procedures in the second podcast. Today, we're going to start by talking about the removal of the terms of reference. And for those who are unfamiliar with the terms of reference, they typically set out the parties' claims, the relief sought, the procedural framework for the arbitration. And in practice, many users viewed them as adding cost and procedural complexity without having a large benefit on the narrowing of the dispute at such an early stage. Chris, we touched in the first podcast that neither of us were particularly big fans of the terms of reference. Again, I suspect there's little to add on that, but they weren't for you, I take it.
I think we can live pretty comfortably without terms of reference.
Indeed, and they've been a key feature of ICC arbitrations for many years. But the key in these new rules is that they're no longer going to be mandatory. So other institutions have taken various approaches which sidestep the need for terms of reference, and it's not novel that an arbitration can be conducted effectively without the need for terms of reference. It's been the case for some time now that when following the expedited procedure, terms of reference aren't required. And Chris, in your experience of that expedited procedure, not missed?
Not this. They didn't want to get rid of them entirely, so they dipped their toe a little bit in seeing how it would play out, removing them for the expedited procedure. But I guess time will tell. But I suspect people will forget quite quickly about the terms of reference and will um, be happy to make sure that everything is framed appropriately in terms of procedure and everything else in the first CMC and the first procedural order.
So the terms of reference are a key part of the ICC arbitration procedure, or at least they have been to the inception of these rules. Chris, what's the usefulness of the terms of reference in practice?
They historically were useful in framing what fell inside and outside the scope of the arbitration. So if a party made an allegation later or brought a claim that wasn't fully encompassed by the terms of reference, then you would go back and say, aha, this claim wasn't envisaged at the start, it's not been the scope of this arbitration, and you can't advance that claim now. So, in a way, it was a filter trying to pinpoint at the start of the claim what would be encompassed in that arbitration or not.
Yeah, absolutely. And in terms of the impact on future arbitrations, I mean, the ICC has been an effective institution for decades, and um, the terms of reference are not expected to be admitted in every case. But I think realistically, a high percentage of them are going to see the terms of reference omitted. Um,
Yeah, what we see is the ICC really coming into line with the other arbitration institutions that we talked about. And I think the way they will try and limit parties from trying to shoehorn in fresh claims later is to make it very difficult for parties to bring claims that weren't identified at the time of that first CMC. So the CMC, the first CMC, will serve a filtering system at really trying to pinpoint at that stage what the arbitration is about.
yeah, I suppose there you're talking about Article 25 in these new rules, and it's not going to be an unfettered ability for parties to introduce new claims throughout. The cutoff is going to be that first CMC.
The tribunal will have a discretion, and we'll see in practice how ready tribunals will be to exercise that discretion.
So, in terms of the implications, are we going to see a need to front load more of a case preparation in advance of that first CMC?
I mean, I would think so. I think people should start the arbitration really identifying their claims so that people know the case they have to meet. It's never satisfactory where a party is ambushed late in proceedings with a claim that should and could have been brought a bit earlier.
Yeah, and I suppose the other benefit is that it's going to be will hopefully be able to reduce early delays, especially with non-cooperative parties. Um, but it does require some strategic planning up front.
Indeed.
So let's touch on briefly the impact on drafting dispute resolution clauses in light of some of these new expedited procedures. My gut takeaway is that there's no specific need to incorporate anything into contracts immediately. It's currently only a pilot project, and parties can opt in at a later date to the highly expedited procedure. But it's certainly something to think about in the future, Chris.
That's right. To recap, with the highly expedited process, that is opt-in only. So the parties both have to agree to do it. And if you contrast that with the normal expedited process, that automatically applies unless you opt out. And of course, if it doesn't apply to you, parties can nevertheless choose to do it. So there are various things you can opt into and opt out of. And so when parties now are settling the dispute resolution clauses, they all think, if I'm going over the ICC, in what circumstances, if any, do I want to use these procedures? What we might see is people having a hybrid process for certain claims if they really think, that they can anticipate there might be a debt claim, for example, that be very straightforward. They might just earmark that and say that's good for the highly accelerated process, or they might have a process that pushes claims of a certain value down a certain route. I think we'll just have to see what people decide to do, and of course, parties should get legal advice on what might be best suited for their situations. I think you and I might be slightly cautious about um, recommending parties opt into HEAP now when it's at the very early days. And it may be a better call to be made down the line when the dispute's actually arisen and we can see how HEAP is really performing in reality.
Yeah, absolutely. And in terms with choosing whether a an opt-in clause to the highly expedited procedure is right. Parties are really going to have to think whether they're prepared to take a hit on the submission opportunities that the procedure offers. And it's one of the beauties of arbitration, isn't it, Chris? That it can be so bespoke that it does give the parties a large amount of flexibility, and it's a element of flexibility that they can even consider long before the arbitration presents itself. That they're agreeing the underlying contractual documents which will ultimately host the arbitration agreement.
Indeed.
So, in terms of other practical steps for practitioners, we've mentioned a couple of times about front loading the preparation just by the nature of this slightly different ICC procedure. But there'll also be some risk management points to consider, and assessing the enforcement implications. And Chris, what are the key things you're going to have to consider when it comes to enforcement?
Um, well, one of the grounds on which you can challenge an award is if you haven't had a proper opportunity to put your case, or where a tribunal has not given reasons for its decisions. So we can see that if there's a process where, for whatever reason, a party is unhappy because it feels that it wasn't able to properly put its case given the limits of the particular procedure that it had agreed to, um, and that it was deprived from that opportunity to put its case, didn't get a fair shake, um, that might be a ground of appeal that's pursued in the future. And likewise, if you go through the highly accelerated process, we get an award which either doesn't give reasons or gives very threadbare reasons. Again, depending on the seat where enforcement is being sought, they might a court being asked to enforce this award and say that assets can be executed against in that jurisdiction. A judge might be uncomfortable if he hasn't seen this process before in allowing a party to enforce. So again, we'll have to see how this plays out in practice.
Yeah, you can foresee some courts around the world being very slow to rubber stamp an award with no written reasons
Mhm.
whatsoever that's been decided within 3 months. And the only final practical step I have to mention is training and preparation. As always, careful consideration of new provisions and their practical implications will be essential, both for the parties themselves, the solicitor teams, and counsel. And the utility of some of these changes will be put to test over time, and it's going to be a learning curve for everyone. And the only thing I wanted to add at the end here, Chris, is these rules. I think you described them as at the outset of the first podcast as a major overhaul, and I think that's right. But they do show, and they are illustrative of the parties' desire to have a more efficient and streamlined arbitral process. Just wanted to touch on where we think this could end up. What are we going to see in the next iterations of the rules in 4 or 5 years' time? And the big topic on everyone's mind at the moment is AI. And if we're already seeing the possibility of awards which have no written reasons, how far away in practice do we think we are from not necessarily the ICC, but other arbitration institutions being prepared to take a big leap into that AI world and leave the decision making to the computer?
Yeah, well, we're in the early days of AI, and I think we both have encountered AI work product in our practices. I don't think it's anywhere near where it needs to be for either drafting submissions or taking the role of a decision maker now. Um, we'll just have to see how the technology develops. I suspect for, say, disclosure, legal research tasks, you can see a world in which tribunals would be receptive to the use of AI, where work can be produced reliably and for a minimal cost. As for actually having an AI judge who will sit there as the arbitrator and decide a dispute, um, who knows if people are happy to have their disputes resolved in that way because they perceive there'll be a cost benefit or whatever else. Um, it's an interesting prospect, but again, you'd have your problems potentially down the line with enforcement and everything else. And the reason lots of people want to actually take a case all the way to trial and have it heard by an arbitrator is because they want a human being hearing them put their case. And I don't think a computer would ever really be able to step into those shoes.
Yeah, no, I agree. I don't think they'll ever be able to step into those shoes. But it does seem, in some ways, the next logical step in efficiency. But we'll have to wait and see on that one. I mean, if I was uh, working for an arbitration institution, I think I'd be certainly considering investing in our own tool or model that can understand and push forward that decision making process. Because I think in the next iterations of these rules, we're going to see many institutions building their own products, building their own tools, and trying to showboat their offerings in the AI space to the world.
Interesting times.
Interesting times indeed. Well, thank you everyone for coming along this journey with us of these 3 podcasts on the ICC arbitration rules. If anyone does have any questions, queries, or a burning desire to discuss these rules in more detail, my details and Chris's details are available on the webpage, and feel free to get in touch. Thank you very much.
Thanks very much, Joe.